So another document, this is again another living document, it's called a healthcare power of attorney. It's same conceptually as the financial one, but it speaks to your healthcare matters, your medical decisions, those sorts of things. So if you lose capacity, remember all I'm talking about right now are people losing capacity. What we don't want ever to happen. But this is what elder law really focuses on, is what if you lose capacity? If you can't speak for yourself, you really want somebody else to speak for you. Talk to your doctors. You know, who should you appoint? Same with both of these, financial and medical. Somebody you trust, somebody who's a capable and effective advocate for you. They don't have to have medical training, but they need to be sharp enough to ask questions, to follow whatever the doctors are telling them, and to make decisions, and sometimes those are hard decisions. Now, one of the things that I very much recommend is whomever you're appointing, let them know that you've done so. It really comes as a surprise, right? What? I didn't know I was your healthcare agent. You say to the person who's lying in the hospital bed, you didn't tell me this. That's an unpleasant surprise. And also you're telling them, you want to be talking to them, giving them information that they might not know so that they can be your best advocate for you. Now, it is not necessary that your powers of attorney be separate documents, one for finances and one for healthcare. We at our office typically draft them separately because maybe your financial power of attorney is your son, your healthcare power of attorney is your daughter. There's all sorts of reasons why you would want it to be a separate document. So, and especially our documents are pretty robust. They really cover all bases. But you'll see, especially online form documents will be combined into one, and there'll just be one paragraph that says, this person is my healthcare agent. There's nothing wrong with that legally, but from an elder law perspective, when I am trying to help protect you, your family, and your money, I like to have a more robust document that allows us to do whatever planning would benefit you. Yeah. Oh, over here. Yes, sir.
Would you recommend somebody that you appointed POA to talk with the elder law like you?
Yeah, that's a great question. So the person you've appointed under your powers of attorney, they're called your agent, your attorney, in fact, your POA. The question is, should they come talk to the attorney that drafted the document? The answer is yes. We like to encourage, once our client has signed the document, who have you appointed? It could be a spouse, it's usually a son or daughter or somebody. Come in and let's go over all the documents. Let's give them an understanding of what they should be doing. So yeah, I think it's a great idea for that person to come in and speak with you, me, at a group meeting.
When you can't do that, like my granddaughter is our attorney, and she's in Billings, Montana. Mm-hmm. Is there people that would go talk to her then from Billings?
We Zoom, phone call, video, I know. We just came out of a world of 2 years of Zoom. Nobody probably wants to do it anymore, but there are ways to communicate with people who are remote. Of course, we all know the phone call. That's one way to do it. If it's your granddaughter, she probably would be happy to Zoom video on the computer, yeah. Yes, sir, in the back.
In durable power of attorney, do you have then backup in case people are?
Great question. You want backups on your power of attorney. Remember I said what we do in estate planning and elder laws, we say, what if this, what if that? Well, what if you, nominate your spouse and you and your spouse are in the same car accident? Who's backup? Well, then it's gonna be my daughter. Okay, what if all three of us were on a plane somewhere, and now who's backup? My son. So we like 3 levels of backup, actually. Yeah, it's a really good question. And I do not like joint decision makers. I don't want it to be a committee. Appoint somebody who will make the decision, but do appoint backup successors. The reason that you want that is if you run out of successors and you don't have a mechanism in your document to appoint somebody else, the document fails and you're in court under court of guardianship. We put in our powers of attorney that none of these people can serve, then the majority of the adult members of my family can appoint somebody, because we always want to keep the decision-making authority within those people who are my family, not the court. You guys have great questions, keep them coming, thank you. Yes, sir?
In the absence of a trusted person, do attorneys serve as attorneys in fact?
In the absence of a trusted person, do attorneys serve as attorneys in fact? I can't speak for all attorneys. I know at our firm we don't do that. That's not the best use of our time and your money. Lawyers cost money. So the better use is to hire, there are professional fiduciaries. For example, let's say you have money under investment at Washington Trust Bank, they'll be your financial power of attorney. Or Northwest Trustee and Management, they have a fiduciary service. They'll serve as a professional attorney in fact for you. And you know, it's more common that people appoint family members, but it's not uncommon that a professional needs to be appointed. And when it comes to healthcare, you can ask around with the booths here, but I do know various healthcare agencies will serve as your healthcare agent. Village Plan is one of them. Of course, they charge money, and so that's kind of the resistance to appointing a professional, but sometimes it is the best option.